All right, well, thanks for joining us on this. So what I wanted to give you an overview about is, and I have no disclosures, basically the process from the board side. Obviously, I'm going to tell you what Nevada law says, but I believe most states are going to have very similar process, so hopefully it will still be helpful to you. So the number one thing to remember when you receive a summons and a complaint in a malpractice lawsuit, you need to let your board know wherever you're licensed. In Nevada, you have 45 days to do that, and basically in writing, you can just let the board know that you've been served with this complaint. You can include a copy of it as well. Often attorneys will do that for you, but just make sure that your board is informed. And I wanted to give you an idea of the importance of that because the board will receive information from multiple sources. So by law, the physician will tell us about the case. Also, insurance companies, other individuals will report it to the board. So you want to make sure that you're also doing your part so that you're not the one that's not reporting timely. So again, your first thing is when you receive the lawsuit. The second thing would be if that claim in Nevada anyway, if it goes to arbitration or mediation, you want to let us know that. That's not very common in my experience, but if it happened, you would want to let us know. The other thing would be once it's paid, settled, or otherwise disposed of. So if it's dismissed, let your board know. If a payment is made by your insurance company, let the board know. If it goes to trial, let the board know. And again, there's a 45-day window in Nevada for that. Also, you have to let the board know if there's sanctions imposed that are reported to the National Practitioner Data Bank. Hopefully everyone's familiar with that. I know in Nevada anyway, when you're first licensed, you'll submit a query, so I'm sure you all are familiar. But if you do have something reported, not just a malpractice lawsuit, but often these will be reported as well, if the dollar amounts meet the threshold, you want to make sure you report that as well. And then lastly, if you don't report, there can be a fine, there can be other sanctions. And so you don't want to add on to what you're already working with. So the insurer also has an obligation, and theirs is also 45 days from when you let them know that you have received that summons and complaint. Again, if it goes to arbitration or mediation, they're to let us know. So in a perfect world, obviously, the board would be getting 2 reports every time something happens in the case. Not later than 45 days after there's a settlement, award, judgment, or even if it's dismissed, they are to let the board know. And then again, if they don't, we actually in Nevada are supposed to report them to the Division of Insurance because they're licensed as well. I'm sure something's very similar in other states, and so it's in their best interest to make sure that they report to us as well. I will say most of them report through the data bank, so that's how they report, at least that disposition piece, is once something happens, they report that payment, for example, and then they'll also request that that get forwarded to the board. So it's usually a little bit more automatic. The court also has a duty to report, so if a physician is found to be liable for malpractice, the court has a duty to let the board know. Same as if there's other things, I put others on the list also because if a physician is found, let's say, incompetent, having other issues that might affect their ability to practice, they have a duty to let us know. And then also sometimes the plaintiff will file a complaint along with the board, along with their malpractice lawsuit. So again, we would have it from hopefully the physician, the insurance company, and then of course we're going to have that plaintiff complaint. We're going to put them all together. We're not going to investigate it 3 times, but just so you're aware that if you don't file the complaint with us or let us know about it, that could potentially be bad because we will find out about it from other parties. So basically my tip for you is just to make sure you check your statutes in the state where you live and are licensed, and if you're licensed in more than one, make sure you're aware of all of them because you're going to have time frames. My guess is going to be 45 days, it might be 30 days, probably not less than 30, but just keep that in mind. And what do we do? So the investigation that the board does is different than the investigation, the process for the civil court. So in Nevada, what we're going to do is we're probably going to open an investigation. Obviously, we'll review the report, review the complaint, and kind of see what's alleged. Most likely, we will open an investigation. We have an investigative committee in Nevada that is made up of 2 physicians and 1 public member, and they help that investigation process. So it's not just staff of the board that's looking at these things. So if we do that, we will send a letter to the physician that says, we've opened the complaint, it's our understanding this lawsuit is pending, please tell us about it and give us some records regarding this case. Then we will have a medical review, which is done by a physician employed by the board. Usually it's an internal medicine doctor, family practice. They will review the case and the file and basically, I would say, kind of decide if they think there's something there. Generally speaking, in a malpractice case, unless it was just very sloppy, we're probably going to continue to look at it past that level, that medical review level. So in that case, what would happen is we would ask a peer review be done. And the board is going to have their own peer review. And that peer review will look at all the medical records and basically make an independent assessment for the board as to whether or not there's a belief that the physician violated the law. And we're looking at Nevada law, and we're not necessarily looking for the same things that they would look for in a civil case, a civil malpractice case. And so it's not uncommon sometimes for you to be, for example, disciplined by the board if the malpractice case is dismissed and vice versa. That can happen because we're looking for different things. So malpractice in the board view is not the same. So I've given you the definition there in Nevada, and it's the failure of a physician in treating a patient to use reasonable care, skill, or knowledge ordinarily used under similar circumstances. So you might notice we don't have to prove injury. We don't need to prove that the patient was actually hurt, just that the physician did not act properly in treating that patient based on that expert opinion. So again, it's different than the civil case, and so just be mindful of that. And we also, again, why don't we have to prove harm? And the real reason is we're not trying to make plaintiffs whole. So the civil system, the court system is saying somebody was hurt, who should pay for that hurt, right? That's kind of the idea behind the system. And so if someone was hurt, somebody should pay. But in our case, we're looking to protect the public. We're not trying to get money for anybody. And so we're really just looking at whether or not the physician acted appropriately. And so again, just remember that you'll want to report to the board, and you'll want to make sure that you respond to the board in that investigation, and just be aware that because we made it close the case, the civil court could find that there was a violation there and vice versa. So don't assume that they will always be decided in the same way. I would say most of the time they are, but I would just say most, maybe 60-40, maybe 70-30. It's not overwhelming, I would say, because again, we're looking at very different things. And that's all I have.